will be discussing the definition of war.
War is violence involving the use of armed force between states. There were also early attempts to outlaw war, such as in Hague Convention in 1907, Covenant of the League of Nations in 1919, and Kellogg-Braid Pact for Renunciation of War in 1928. But these events did not prevent World War II. It was after World War II that a more effective law on preventing war was formulated, and it is called International Humanitarian Law. It does provide, for instance, when the use of armed force is justifiable or jus ad bellum, and it regulates the conduct of armed conflicts or jus in bello. So the main goal of the international humanitarian law is to limit the effects of war on people and property, and which protects certain particularly vulnerable groups of people.
The legality of war. There were early attempts of outlaw of war, such as the Hague Convention II, 1907, in the Covenant of the League of Nations, 1919, and in the Kellogg-Briand Pact for the Denunciation of War, 1928. Based on the Article 2.4 of United Nations Charter says, all members shall refrain their international relations for the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of United Nations. In effect, this provision outlaws war. Three facts can explain the paradox. 1. Those who resort the use of arms do not give up until they achieve victory. 2. Give the first fact. Humanitarian considerations dictate the need for rules which curtail violence beyond what is necessary to achieve a state's goal. 3. There still remains the heart the soldiery and acceptance of chivalry as value. The Hague Law. Early laws of war were customary. At present, the laws are largely conventional. In 1899, 26 countries met at The Hague and formulated the conventions and declaration. More conferences were held in 1907. The Geneva Conventions of 1949. One of the most significant developments in the law of armed conflicts was the adoption of 1949 for Geneva Red Cross Conventions governing 1. Wounded and sick in the field. 2. Wounded, sick, and shipwrecked at sea. 3. Prisoners of war. 4. Civilians. The essence of Geneva Conventions is that persons not actively engaged in the warfare should be treated humanely. The rules apply to any
So next is the rules of warfare, or formerly known as international humanitarian law.
First is to protect those who are not fighting, such as civilians, medical personnel, or aid work. Second is to protect those who are no longer able to fight, like an injured soldier or a prisoner. Third is to prohibit targeting civilians. Doing so is a war crime. Fourth is to recognize the right of civilians to be protected from the dangers of war and receive the help they need. Every possible care must be taken to avoid harming them or their houses or destroying their means of survival, such as water, sources, crops, livestock, and etc. Mandate that the sick and wounded have a right to be cared for, regardless of whose side they are on. Specify that medical workers, medical vehicles, and hospitals dedicated to humanitarian work cannot be attacked. 6 is to prohibit torture and degrading treatment of prisoners. Specify that detainees must receive food and water and be allowed to communicate with their loved ones. Next is to limit the weapons and tactics that can be used in war to avoid unnecessary suffering. And lastly, explicitly forbid rape or other forms of sexual violence in the context of armed conflict.
Sanctions of the laws of war. In international law, sanction can be defined by an action carried out by one or more states towards another one to force the latter to comply with its legal obligations. In domestic law, sanction relates to the penalty annexed to a violation of a law as a means of enforcing it. The two main kinds of punishments are penal sanction and disciplinary sanction. First is the penal sanction. Penal or criminal sanction are pronounced by national courts in conformity with the rules of due process of the law. Lastly, disciplinary sanction, imposed by a superior against a subordinate under his or her authority who violated an internal regulation. Sanctions taken against individuals are defined by domestic laws and are scaled according to the gravity of the offense. They include the following: death penalty, deprivation of liberty, fines, corporal punishment, punishment by compensation, and lastly, some communities punish individuals by banishing them from their society.
Termination of war. The first mode of termination of war is treaties of peace. The feature of peace treaty is that both brings an end to pre-existing state of war and creates or restores friendly relation between the parties. In this sense, two temporal matters are noteworthy. The first refers to the set of point at which the end of war takes place. The second temporal problem that is not possible to synchronize the two cardinal aspects of peace, the end of war, and the normalization of relation. Second is the armistice agreement. In the current practice of the nation, an armistice primarily signifies an end to the war, fully depriving the parties of the right to renew military operation under certain circumstances. An armistice of this type brings an end of war and does not only suspend the fighting. The other modes of terminating war. First is implied mutual consent. When belligerents enter into a peace treaty or armistice contract by mutual consent expressed in the instrument, war is terminated. Second is debellato. Debellato is a situation in which one of the belligerents is utterly defeated to the point of total disintegration as a sovereign nation. Lastly is unilateral declaration. The technique of unilateral declaration can be looked not as an independent mode for bringing war to a close, but as an offshoot of one of the two methods. State A can impose war on State B by unilateral declaration or act, just as State B is unable to prevent the State A from submerging them both in war. Unilateral declaration by State B promulgating the war is over has a valid effect only if a State A either completely defeated.
The outlawry of war.
Outlawry of war. If a nation is attacked, it will have the right to use any means to defend itself. But once the attack is repelled, it must submit the boundary at issue to settle by pacific means and not try to impose its own will by war. It is an act of putting a person beyond the protection of the law for his refusal to become amenable to the court having legal jurisdiction. Outlawry of war, it may also called the substitution of law or judicial tribunals for the political international affairs. The outlaw of war involves the three leading propositions. First, creation of a collection of international law, the enhancement and codification of global law. Second, the establishment of an independent judicial tribunal with the capacity to choose and decide or control, including development of global law or settlement. Third, collection of international law will proclaim war wrongdoing and at this point that doesn't perceive in any capacity or at any time war as a real organization for the settlement of the global questions.
So next one is collective self-defense. Article 51 states that nothing in the present charter shall impair the inherent right of individual or collective self-defense if any armed attack occurs against a member of the United Nations until the Security Council has taken the measure of necessary for the maintenance of international peace and security. The simple interpretation of Article 51, it allows the use of force in self-defense. Collective self-defense is recognized not only in Article 51 of Charter of United Nations but also in Article 52, Section 1. It is stated that nothing in the present charter precludes the existence of regional agreement for agency for dealing with such matter relating to the maintenance of international peace and security as appropriate for regional action, provide that such agreement of agency and their activity are consistent with purpose and principle of United Nations.
Collective security. On the year 1914, the modern idea of collective security was born. The development of this idea was triggered by the shock from World War that forced a total consideration of the old ways of diplomacy, rival alliances, and balance of power. It produces different plans and strategies to prevent aggressors in bringing threats to states such as the League of Nations. The League of Nations is created to confront aggressive states and serve as the key in solving dozens of international crises. Aside from that, it's also created to stop the possibility of another war. But unfortunately, the League of Nations couldn't stop the war, and that war causes the League of Nations to collapse. From that, the current President of the United States of America, former President Roosevelt, fused a plan for building a collective security. But what exactly is collective security? Collective security is regarded as the most effective instrument of maintaining peace, an instrument that assures not only the security of all nations but also assures that any attempt to use force in international relations will be frustrated. Additionally, under collective security, aggression or war will no longer be the problem or concern of an individual nations, but would be the concerns of all nations. The basic principle of this device is one for all for one, means that for every attack on one nation, it will be reflected as attacking the other nations. This helps maintain peace and prevent or counter any attack from the aggressors.
And now, let's move on to the use of force in the United Nations.
The six purposes of the use of force of United Nations Charter, those are peace enforcement, sanction enforcement, self-defense, protection civilian, protection of humanitarian activities, and intervention of human conflict. Article 2 provides a better collective security system, but its interpretation is still debated since certain terms of the article has not been explained properly. The scope of prohibition of the threat of use of force is not prices given. Article 51 of the United Nations Charter gives the inherent right to the state to use self-defense, but while exercising this right, the state cannot infringe the right of another state. The states are allowed to force only special circumstances, but states continue to use the force under the circumstances as well. The state before the presence of United Nations, states were free to decide whether to wage war or not to wage against one another. There was no regulation on the state for the use of force. The effect, United Nations after the establishment has been successful in dealing with the use of force by the states, but it faced criticism. Under Article 2.4, only military force is prohibited. Psychological or economic pressure does not come within the purview of Article 2.4 unless coupled with the use of threat of force. Refusal of one state of trade with another is not consideration a violation of international law. Consequently, only military force were prohibited, not any other sanction in 1945, and that position has not changed till date.
The peaceful means of settling disputes. There are three methods of settling disputes. First is the non-judicial or diplomatic method. Second is the quasi-judicial method. And last but not the least is the judicial method.
What is negotiation? Negotiation is the most used medium to settle disputes. There are no specific set of rules for negotiation, but for a negotiation to be legally binding, both concerned parties must agree to it. The agreement for negotiation can be formalized by forming a treaty, but can also be a simple exchange of notes. Second is mediation. Mediation is when both parties need the help of a third party to act as a bridge, primarily due to that the concerned parties cannot meet. It can act as a chair during meetings or discussions, suggest solution, kaholan, etc. The mediator must also be approved by both parties. Third is inquiry. Inquiry is fact-finding mostly done by professionals and designated group of individuals or institution. When both parties have approved, the dispute is mostly settled by the means of interrogation to get facts. Fourth is conciliation. Conciliation is a more formal technique where the concerned parties agrees to consult the issues to an individual, a group of individuals, or an institution to come up and find information based on facts and recommendations to make a solution. As a rule, parties don't agree just to be bound by recommendations. Remember, the key word is that the two parties with disputes only gave recommendations for the parties to reconcile. Quasi-judicial method. There is only one method in quasi-judicial method. It is arbitration. Arbitration is the binding settlement of a dispute by using or basing the law by a non-permanent body designated by the concerned parties. The composition, the jurisdiction, and the rules of procedure to be applied are agreed upon by parties in a compromise d'arbitrage. States cannot be required to submit to arbitration unless there is a previous agreement making arbitration compulsory. Judicial method. Just like quasi-judicial method, there's only one method in judicial method, which is the judicial settlement. Judicial settlement is a settlement of dispute between states by an international tribunal in accordance with the rules of international law. The international character of the tribunal in both its organization and its jurisdiction.